Good afternoon. I'm Ellen Rosen, president of the Chicago Council of Lawyers, and I am so glad you could join us today for the first of our 2 October Collaboration for Justice events. We have got some truly incredible sessions and speakers for you to highlight our critical work to improve the effectiveness and fairness of and access to our justice system. This work is what the Council has been about since our founding in 1969. Our founders wanted to take on prevailing unfair laws, policies, and practices, and they recognized that lawyers wanted and needed a place to advocate and to act collectively to do that and to accomplish systemic reform. We were and still are that organization in Chicago. We're not a traditional bar association, and while members of the legal profession make up our membership, we serve the public, the consumers of the justice system, particularly the poor and disadvantaged populations who continue to lack equal access to the courts and to legal services, those who are not treated with requisite fairness and equity once they find themselves in the system. We have made tremendous inroads over the years, and in 1997, we partnered with the Chicago Appleseed Center for Fair Courts as the Collaboration for Justice. We did this to better enable both entities to broaden their reach, leverage unique organizational strengths, and frankly, just to get more done. Chicago Appleseed is one of 16 Appleseed networks around the country working to create a fair, accessible, and anti-racist legal system. Together, we advocate for, achieve adoption and implementation of, and promote systemic reforms that improve access to justice in both the civil and criminal courts. We focus on immigration issues, criminal justice reform, and you're going to hear more about that today, family law and domestic relations, police accountability, and projects in the federal courts. Working side by side as the Collaboration for Justice, the Chicago Council of Lawyers and Chicago Appleseed have become an increasingly effective force. In just the past year, we have, with our coalition partners, successfully advocated for legislation that ended money bail in 2023, and we helped pass the Joe Coleman Medical Release Act that creates a system for compassionate release in Illinois. We have published a variety of data-driven, data-rich reports on a range of access to justice issues, including the recent release of the 10 facts about pretrial electronic monitoring, solutions rather than obstacles, and evaluation of the Domestic Relations Division's hearing officer program, and a progress report on the status of the first 100 days in the transition in the office of the clerk of the Circuit Court of Cook County. We've monitored the spread of COVID-19 in jails and prisons throughout the state and successfully advocated for prisoners to get access to vaccines early to help prevent community spread. We monitor the Illinois Supreme Court suspension of speedy trial rights and continually evaluate the Cook County Criminal Court case backlog. The Council's collaborations and Chicago Appleseed's full panoply of accomplishments can be viewed online, and I encourage you to do so. Our successes and strength would not be possible but for the council members, our pro bono volunteers, our donors, our sponsors, our community partners, and the tremendous staff that support our work. We are so grateful for all of you, and we thank you. And we'd love to have those of you who haven't yet done so join us in fighting for a transparent, equal, accessible, and effective justice system. If you aren't already a council member, please visit www.chicagocouncil.org and join us. I also encourage you to please make a donation to Chicago Appleseed at chicagoappleseed.org. These donations are critical to the collaboration's ongoing work. This month, we've put together an array of experts who are going to talk to you virtually, because unfortunately we can't be together in person quite yet, about the hidden injustices in our courts. Today, we have the end beyond the end of bail. And on October 19th, we are truly honored to present a dual keynote presentation by Illinois Attorney General Kwame Raoul and Chief Justice of the Illinois Supreme Court, the Honorable Ann Burke. And they're going to talk with you about eliminating disparities in and improving the Illinois courts and what the judiciary can do to help ensure accessible justice for all. So if you haven't signed up for that October 19th event, you can do so at chicagocouncil.org, and I hope you will consider joining us. Before I turn things over to Natalia Vera, my colleague on the Chicago Council of Lawyers Board of Governors, she's going to introduce today's panelists. I once again want to thank our incredible staff and give special thanks to our executive director and to all of the council collaboration and Appleseed staff members and fellows. They're incredible, they're invaluable, and they're deserving of your applause. So thank you again for joining us. And now I'm going to turn things over to Natalia.
Thank you, Ellen. As Ellen explained, Chicago Appleseed Center for Fair Courts and the Chicago Council of Lawyers work together in a collaboration for justice to promote fair, accessible, and anti-racist courts. Every year, we hold an annual meeting in October. This year, we're excited to host a two-part series focused on how we're collaboratively identifying and fighting hidden injustices people face as they navigate the legal system. But before we begin today with our panel discussion of the Pretrial Fairness Act, what challenges we face for implementation, and why abolishing money bail is essential to racial, gender, and economic justice, I would like to introduce our panelists. First, we have Sarah Stout, Senior Policy Analyst and Staff Attorney for the Collaboration for Justice. Sarah has been a Senior Policy Analyst and Staff Attorney since 2018. She graduated from the University of Chicago Law School in 2013, and before coming to work with us, was a criminal defense attorney with the Lawndale Christian Legal Center, where she represented juveniles and young adults in the Cook County criminal courts. Sarah leads the collaboration's criminal legal reform work, focusing on projects related to electronic detention, abolishing overly punitive sentencing systems, and promoting court system efficiency, fairness, and accountability. Sarah's work has largely focused on pretrial court reform. Through our work as a member of the Coalition to End Money Bond, she was instrumental in the drafting and advocating for the groundbreaking Pretrial Fairness Act, which makes Illinois the first state to fully end money bail and restructure the pretrial justice system starting in 2023. Next, I would like to introduce Garion Gatewood, Director of the Illinois Prison Project and board member of Chicago Appleseed Center for Fair Courts. Garion joined the Illinois Justice Project in April of 2019 and became the director in 2021. Previously, he was the director of policy advocacy at the Juvenile Justice Initiative, where his work focused on legislation on both local and state levels, with a focus on the rights of children, detention reform, eliminating youth homelessness, juvenile expungement, and reentry. Garion earned his law degree from the University of Mississippi and worked for the Children's Law Center, focused on reentry services for youth throughout Ohio and Northern Kentucky. During his time in law school, he clerked with the Southern Poverty Law Center and the Mississippi Innocence Project. Currently, Garion sits on the Cook County Juvenile Temporary Detention Center Advisory Board, the National Juvenile Justice Network's Membership Advisory Council, the Board of Directors for Restore Justice Illinois, and the Board of Directors for Chicago Appleseed Center for Fair Courts. As part of the Illinois Justice Project, he has also been intricately involved in the work of the Coalition to End Money Bond. And last, but certainly not least, I would like to introduce Senator Robert Peters, Illinois State Senator for the 13th District. Senator Peters is a proud Southsider and an even prouder Chicagoan. His passion for public service was cultivated by numerous events throughout his life that left a profound impact on him and the people he cares about. He was born deaf and faced a variety of struggles with health and environment in his early childhood. Senator Peters credits his public school teachers and administrators for checking on and guiding him. And by the age of 8, he gained full hearing ability and full speech capabilities by the time he was 12. Senator Peters' adopted mother and father were a social worker and a civil rights lawyer, respectively, which helped inspire his mission to fight for criminal justice reform. After college, he started as a community and political organizer here in Chicago and was part of a successful movement to require Cook County judges to set affordable bail amounts for all defendants in 2017, leading to a substantial reduction in the Cook County jail population. As a state senator, he has continued advocating for pretrial justice, working hand in hand with the Coalition to End Money Bond, and was a chief sponsor of the SAFETY Act, which will end money bail in 2023 and includes a range of other criminal and policing system reforms. In the 102nd General Assembly, Senator Peters will serve as the chair of the Public Safety Committee and it's a member of the Criminal Law, Environment and Conservation, Health, Human Rights, Labor, and Revenue Committees. Thank you all for being here today. And now I would like to pass on the virtual mic to Sarah to do a brief introduction on today's topic. Sarah?
Hi, everyone. Thank you, Natalia, for such kind introductions. I'm Sarah Stout, the Senior Policy Analyst and Staff Attorney at Chicago Appleseed and the Collaboration for Justice. I want to start today, before we go into our wonderful panel, by giving everybody an overview of what exactly the Pretrial Fairness Act does. So for those of you who don't have a lot of background on our money bond system and why exactly we needed to change it, we went into our money bond system is one of the more oppressive features of the criminal justice system as it currently exists. It basically allows money, whether or not you have it, to determine whether you're in jail, instead of using some more rational process that actually looks at each person individually to make decisions about who should or shouldn't be jailed pre-trial. The Pretrial Fairness Act was the result of years and years of advocacy by many organizations throughout the state, and was ultimately passed this February 22nd. It was signed into law as part of something you may have heard of called the Safety Act. The Pretrial Fairness Act is like a subset of the Safety Act, which deals specifically with our pretrial system and basically overhauls everything that happens between when someone is arrested and when they go to trial in Illinois. It is truly revolutionary legislation. It is undeniably one of the largest criminal justice packages or one of the largest criminal justice changes ever passed in Illinois. And it is one of the most progressive packages on pretrial reform passed in the country. I am incredibly proud to have been a part of this effort, and I'm incredibly proud to be sitting next to Senator Robert Peters and Gary and Gatewood, who helped make it happen. I want to start by going through just some of sort of the 9 key things. I know 9 is a lot. This is a big bill. This bill is like 300 pages long. The 9 key accomplishments that the pretrial fairness has, so you can get a sense of just how fully it reforms Illinois' criminal justice system. So the first key accomplishment of the Pretrial Fairness Act is the one that I think everybody has heard of, which is that the Pretrial Fairness Act completely ends the use of money bond. As of the effective date of the act, which is January 1st of 2023, so a little over a year from now, in all charges, in all situations, everywhere in the state, money bond will be eliminated. No longer will the size of your pocketbook determine whether or not you are in jail. And that is hugely revolutionary. It makes us the first state and the second sort of entity. The federal government in DC beat us to the punch, but we're the first state to fully eliminate money bond. It makes us really leaders in the country in terms of making our justice system more fair and more focused on economic and racial justice. So this is the key reform and the key harm the Pretrial Fairness Act sought to address. But really, what the bill does that's perhaps even more important than ending money bond is what it replaces money bond with. It's not like the bill just gets rid of money bond and leaves us with nothing. Instead, the bill creates a more fair and equitable system to make decisions about how we use our jails, how we use conditions of pretrial release after someone is arrested, both to make sure that our communities are safe, but also to make sure, and this is what I think truly is the most important thing, to make sure that the presumption of innocence is valued in this state, which is something that over time, as the criminal justice system has grown, our presumption of innocence has really had less and less power. Pretrial Fairness Act begins to restore that. The way it does that is that the Pretrial Fairness Act limits eligibility for pretrial incarceration. By pretrial incarceration, I mean jail. Basically, what the Pretrial Fairness Act does is it says only certain serious charges are eligible for jail after arrest. And even people charged with those serious charges, and these are charges like sex crimes, domestic violence, gun crimes, and violent felonies, things like murder, armed robbery, carjacking. Even if people are charged with those crimes, there has to be a robust hearing that looks at each person individually and asks the following question. Does this person pose a specific, real, and present threat to another person? If they do, if they fit that criteria and they're charged with a serious crime, then they can be jailed. And if they don't, they need to be released pretrial, and they need to be able to fight their case and await their trial in their communities. And that's really important because we should only be using jail, which is the most extreme way we can restrain someone's freedom when we haven't even found them guilty of a crime yet. We should only be using it as a last resort. The other reason that someone can be jailed pretrial under the Act is if they pose a high likelihood of willful flight. So more than just a possibility they might miss court, but a possibility that they really may actually fully abscond from the jurisdiction and flee. So that too is meant to be a very high standard, and one that makes sure that jail is only used as a last resort. Our third major thing the Pretrial Fairness Act does is it reforms the warrant process for missed court dates. A huge proportion of arrests every year in Chicago are for warrants. Basically, when people miss court, and honestly, those of you who have had a traffic ticket may very well have experienced either having an arrest warrant issued for you or threatened to be issued for you. But when people miss court, and people miss court for all sorts of reasons, right now, a warrant is generally issued for their arrest. And that means that when they next interact with police, which in communities that are over-policed, of course, often happens quite quickly if they are stopped by police when they're driving their car or walking down the street. The next time they encounter police, if they've missed a court date, they can be incarcerated. And it often takes days to figure out what's going on and get them re-released, even if the arrest warrant was for a crime that was very, very minor. The Pretrial Fairness Act allows judges to instead give people a much more rational option. It gives people a chance to show up in court within 48 hours rather than immediately issuing an arrest warrant. While judges still can issue an arrest warrant if they want to after someone misses court, we hope that this will encourage judges to use the option that saves resources and also saves people from having their lives totally disrupted from arrests that really don't help anyone, because ultimately they're arrests for missing court. And most people miss court because they didn't have transportation, because they forgot. I mean, God knows all of us forget our appointments occasionally, or because they were stopped by something like a lack of childcare, family obligations, or medical obligations. The fourth thing that the Pretrial Fairness Act does is it reduces penalties for violations of pretrial conditions. One of the major harms of the current system, and this is something that's relatively unique to Illinois, is that when someone is released pretrial and has a certain set of rules attached to them, and these rules obviously are things like don't go to a certain area, or make sure you check in with your pretrial officer, or don't get a traffic ticket. These kinds of rules can lead people, when they're violated, to be incarcerated all the way until their trial, which is essentially indefinitely. Because depending on what you're charged with, trials in Illinois you can be waiting for anywhere from a couple months to a couple years. That's just not rational. It's not rational to be locking people up for months and months and years because they missed an appointment with a pretrial services officer, or broke the rules of electronic monitoring, or missed a court date. So instead, the Pretrial Fairness Act limits the penalties for violations of pretrial conditions so that people aren't being locked up indefinitely for things that wouldn't even be crimes if they weren't in the court system. The fifth thing is that we require reconsideration of pretrial detention and pretrial conditions. Under the current system, once a decision is made about whether you're in or you're out, it often can be very difficult to bring up that decision in front of a judge again and say, hey, things have changed for this reason or that reason. there's more evidence in my case. There's less evidence in my case. I've moved to a different place. I've addressed some concern that the court had. And so people tend to get stuck. We require reconsideration of pretrial detention and pretrial conditions so that judges actually have to make sure that those restrictions on liberty are still justified as the case continues. Our sixth accomplishment, and I know that these are a lot, but I think as you know, I know I'm talking mostly to a lawyer audience, and these are all individually, just to pause for a sec, I want to say, each of these individually would have been a major reform that could have been its own bill. And the fact that the Pretrial Fairness Act has been able to do all of these at once really gives us a stronger pretrial system that all works together. So sorry there are so many of them, but I promise we're at 6 out of 9. The sixth is one that I personally am very excited about. It authorizes law enforcement to release more people with tickets or with court summonses. So right now, we make a lot of arrests, particularly in Chicago, for some very, very minor crimes. One of the most frequently arrested crimes in Chicago is drinking on a public way. It's mostly arrested. They mostly make arrests on the west and south sides, almost exclusively of Black and Latinx folks. And it's simply absurd that we are spending our resources arresting people for public drunkenness when it is an ordinance violation that ultimately is going to be punished at most with a fine. So the Pretrial Fairness Act changes that. It requires police in most circumstances to release people who are arrested, who are accused of ordinance violations like this, or have low-level misdemeanors with tickets that either are tickets like citations that include an actual amount you have to pay, or are summonses to court within 21 days. It also allows police to release people charged with nonviolent felonies and misdemeanors with court summonses. So even more serious cases, if law enforcement wants to create a program where people are able to be released to their homes instead of being held overnight in custody, they can do so. Our seventh reform is that the Pretrial Fairness Act regulates and simplifies factors for judges to consider in making release and conditions decisions. The current law has 38 different things that judges are supposed to somehow hold in their minds at the same time and consider when they're making the decision of whether someone should be held in custody or what conditions should be imposed upon them upon their release. We don't really think that judges are using those factors, and we wanted to make sure that we had factors that actually guide judicial decision-making without having so many that they might as well mean nothing. So we reduced those 38 factors down to 6 factors that are rational, sort of evidence-based and reasonable factors to pay attention to in terms of what conditions are appropriate for someone when they're released pre-trial. We also added an explicit requirement that any conditions that are imposed be the least restrictive possible conditions to ensure that someone appears in court and does not commit another crime. And that's really important. We don't want our courts using pretrial, the fact that someone has been accused of a crime, as a reason to impose conditions on them that aren't necessary to achieve the basic goals that the court should be paying attention to, which is, are you going to come to court? And are you going to get arrested for another crime? The other thing the bill does is it regulates risk assessment tools. Under the current law, well, we have risk assessment. Risk assessment tools are basically algorithmic or other kinds of scientifically based, evidence-based tools that take a certain set of characteristics about people, assign numbers to them, put them through a formula, and spit out a score that may say, for example, how likely the tool estimates a person is to miss court or violate pretrial conditions. We know that these tools often have baked in racial bias that make them very, very hard to reliably use. So we add, the law adds requirements that risk assessment tools be validated and transparent, and gives defense attorneys the ability to look at what's actually going on inside those tools and explain to judges whether or not they're appropriate in a given case. Our 8th requirement is one that's very near and dear to my heart, we ensure sentence credit and basic rights for people on electronic monitoring. Chicago has the largest pretrial electronic monitoring program in the country by far. We currently have over 4,000, we've somewhere between 3,500 and 4,000 people on electronic monitoring in Cook County as we speak. That is in comparison to about 400 in LA, just to give you a sense of how out of step we are with the rest of the country. And these programs are incredibly restrictive of people's liberty. What the bill does is it recognizes that house arrest is a form of jail. If you're locked in your house and you're told you cannot leave without express permission 24 hours a day, even if you get to leave for work and come straight back, that is a form of incarceration. And so the law makes sure that you get credit for it as if you were in jail. It also makes sure that people who are incarcerated in their homes can still get permission for basic activities of daily life, which is something that we've struggled with in Chicago under the current system. So it guarantees a right to do things like buy groceries and make sure that people can in fact go to work and get medical care. And those are just basic human rights protections that were not in place before the Pretrial Fairness Act for people on electronic monitoring. And the last key accomplishment, another one near and dear to my heart, is that we ensure transparency and oversight through data collection and publication. Illinois has some of the worst pretrial data in terms of our infrastructure in the country. We have 102 counties that all keep their data a little bit differently. We don't have a centralized place where we have basic information like how much money is everyone making from pretrial fees, and how many people are in each of the 90 jails in Illinois on a given day. What are they charged with? What decisions are judges making about who needs to be in custody and who doesn't? These are really, really basic questions that under the current system we can't answer. And so the new law creates a system of statewide data collection and make sure that the data that is collected is both centralized so that we can make statewide decisions and published so that we can get access to it as researchers and as the public. So those are my 9 key accomplishments of the Pretrial Fairness Act. I know I went through them quickly. We're going to have a lot of chance during this panel to elaborate on them and talk about why they're important. And I'm really excited to be able to move forward in this and talk to Senator Peters and Garen Gatewood about what we accomplished here and what the next steps are. Hi, everybody. Welcome back. I'm really excited to be on a panel with 2 of my favorite people to work with, genuinely, Senator Robert Peters and Garen Gatewood. It's really a pleasure to have you here and get a chance to talk about this law in front of a room of people who are interested. I'm very excited about this. So I just went through probably, it went through a ton of information about the bill right now. I wanted to start by simply asking, and I'll start with Senator Peters, there are so many different things that this bill does. Of the things that this bill got done, what is the thing that you're the most excited to see go into law when it becomes law in 2023?
I mean, I think fundamentally the fact that we're going to reduce pretrial incarceration, I think is just so important. Zeroing in and focusing on what folks would say is on a threat and focusing in on the sense of safety is something that I think excites me more than anything. But to be honest with you, the whole bill excites me, right? Each component is built together to ensure success and ensure a focus on a broader, newer public safety conversation that needs to happen. And the fact that it's just relatively transformative. I mean, another piece of the bill that stands out to me is instead of having a system where we're overly reliant on risk assessment tools, moving and shifting away from that. Oftentimes when you hear about quote unquote bond reform, it ends up becoming overly reliant on other, forms of surveillance tools or surveillance tech. And that is something that we've, sort of made a shift away from, not necessarily completely, but fundamentally changed away from, which is just different than any other state, let alone just ending cash bond itself. So I'm excited to actually be able to see all these pieces implemented and put into place. I'm excited to fundamentally reduce our pretrial incarceration. I'm excited to reduce our reliance on surveillance tech. And I'm excited to have a conversation that moves us in a different direction about what it means to provide safety for everybody, no matter where they live in the state.
What about you, Garion? What are you most excited about?
Yeah, I'll double down on what the good senator said. I'm extremely excited about what this implementation looks like. And that may be kind of nerdy, but as we're going through the process of figuring out what we know on paper, what's been wrong with the system, but as we go through a process of talking to people around the state, learning more about the decisions that they've made, how we implement pretrial services, how we implement a new pretrial system. I'm over the moon excited about that because one of the things that we really wanted to focus on was how do we bring down this overall population, especially for folks that look like me and Senator Peters? How do we focus in on attacking racial disparities through legislative change, through policy change, but most importantly, how do we view it through a practice change? You can't really implement a policy without changing practices. So it's going to be really important that we, because we have a responsibility. Everybody who is here on this panel and everybody who's listening and everybody who is in the state of Illinois has a responsibility to see implementation through to the end and make sure that this bill is implemented under the guise and under the view of what it was originally intended to do. So that's what I'm really excited about. It'll be a long couple of years. But overall, we're looking at a culture change, a seismic change in how folks are treated in the pretrial system. And we are trying to cut off a gateway to deeper incarceration. So, I'm over the moon excited about this.
Yeah, and I'll say just to add some variety here, what I'm really excited about, although I'm excited about it all because Garion and I are both big nerds here, really excited about implementation. I'm really excited about all of the changes that have to do with how we treat people who have conditions of release after they've been arrested. So after that first bond hearing, because right now in Cook County, for example, we've done a lot of good reform where more and more people are getting released pre-trial at that first court date, which is the first step. But if we have a system where every tiny misstep, every missed court date, every missed meeting with a pretrial officer, if you're on electronic monitoring, literally taking out your garbage can be a route back into jail. We have this hidden path to incarceration where it looks like on paper we're releasing a lot of people and we're doing great, but in fact, we're just providing more opportunities for people to get locked up. I think this bill really thinks about that problem and provides a solution to it, which is exciting because it means we don't have to come back later and fix that, which I think is, and it's going to be an important thing to train judges on, because I think judges are used to being able to have a lot of control over the people in front of them, probably too much control over the way that people in front of them who are charged with crimes live their lives, the decisions they make. And we really want to restore genuine pretrial freedom to accused people. I'm really excited to see how that plays out, although I also think it will be one of the hardest parts of the implementation.
Yeah, I'll just add to this, which is just the plea deal machine is racist, classist, and pretty sexist. And so what we're doing is we're fundamentally slowing down the plea deal machine. And I think when this gets implemented, giving people their day in court, I think is very important. And that's complicated because we live in a criminal legal system and a society that may talk about being innocent until proven guilty, but fundamentally the narrative is guilty and you have to prove yourself innocent. And at the same time, making it very difficult to be able to prove yourself innocent by basically having a churn and burn system in the criminal legal system. And so in this, if we reduce pretrial incarceration because we say less people have to even be held and give more people their day in court. That is fun, an amazing shift that allows people to be able to live their life with their family, allow their kids to be able to, or if they're kids or the parent or whatever it might be, to be able to live their life, to be able to go to work, to be able to go to school. And to be honest with you, if we're going to have large conversations about public safety, and as we know, 2021 has become all about these large conversations about public safety. I like to say that 2020, coming out of a crisis, was an opportunity for a new hope, and 2021 has turned into the Empire Strikes Back. That in that space, then let's actually talk about public safety and let's talk about what people need. And I would make the case that our pretrial system is really at the intersection of a whole host of failures and wrongs that have happened in broader society coming in through the court system itself, and where they're over-reliance on incarceration and the systems of systemic racism and classism and sexism or genderism exist. And so when we can say, no, this is not actually just throwing someone into jail and throwing away the key and calling it a day and being like, you're guilty, and exhibiting broken windows in the behind the scenes unknown process of our court system, we can say, no, that actually won't do anything for anybody. And if anything, will make our communities less safe. And here's what we need to do, and make that argument and make that case. We can get more people, I think, also as an organizing mechanism to buy in on fundamentally changing other parts of our criminal legal system, everything from sentencing to policing. And I think that is just, I think, important parts of this, and allows us to have the space we need to shift the plane to a sort of different system of justice and safety. Does that make sense? That's a lot of words. Yes.
No, it totally
No,
makes
you made perfect sense. You're talking about a culture change, and a culture change is what is needed. And luckily, we have people in an administration in all branches of government who understand the need for that change. And luckily, we have superstars like Sarah Stout who will remain at those tables to try to make sure we get those changes that are necessary. We have champions in the General Assembly. We have champions in the executive branch. We have champions in the judiciary. So we have to do this right. Right? We obviously, we're going to have to fight for some things, which is just a part of life, but we have the support systems around us to truly implement this in a way that we see a real culture change. None of this ticker tape parade around not really having the systemic change that we need. Illinois stands at the crossroads to continue to be a leader in justice reform across the country. And it doesn't start with this bill, but this piece of legislation, the PFA Housing Safety Act, is arguably the most important legislation in the country right now in justice reform, because people are watching to see how we implement what we do. And there's a challenge, again, laid out to all of us to make sure it's implemented properly. We know the senator is down there fighting every day and twice on Sundays to make sure it's implemented properly. And we can't have him fighting alone. So it's our responsibility to help him, help the other leaders, and try to get this thing through and continue to make sure that we see the cultural and systemic changes that are needed.
Yeah, your comment, Senator Peters, about the plea deal machine really reminded me of, I had a lot of, I was a defense attorney for years, and I had a lot of stories in my head that sort of animated the work that I did on this bill. And there's one in particular that really resonates here, which, I had a client, he and his girlfriend, and basically they were being mugged and they fought back, was the basic situation. And because of an odd series of events, that isn't how the police understood the situation. And they both ended up arrested. They each had a $40,000 D bond. They each needed $4,000 to get out. They had an 8-month-old son, who lost both parents to the system, and the cases were pending. They were both facing mandatory 6 years in prison, and the cases were pending for 6 months. It's the only case, for those of you who know how 26th Street works. It's the only case I ever demanded trial on, which is a very unusual thing to do, to try and rush a case because it was so egregious. But in the end, the mom pled guilty to something she didn't do, because she said, I have to see my kid's second birthday. She'd already missed his first birthday, his first steps, his first words. I mean, it was unbelievable. Like and in the end, that meant that, we ended up taking our case to trial. We won one of the counts. We lost the other because we didn't have her as a witness, because she had just pled guilty and said she did something she didn't do. So she couldn't then help her boyfriend. And so, yeah. In the end, all of that would be different. All of it would be different under the Pretrial Fairness Act. And that is, it's really something, there's been so much pain already. And just the idea that maybe the next time something like that happens after 2023, things will go differently is exciting.
Yeah, and I'll just add, and I'll say, I think too often, I think this is for a lot of people, they look at quote unquote crime in a vacuum and they don't ask the questions of why. And I think what is important about the PFA and much of the Safety Act, to be honest with you, and I think the work that we're doing is that we ask the important questions of why and seek the answers, and then constantly struggle with those questions and continue to fine tune those answers. And what I mean is exactly what you're saying. If you take someone like a mom and then she's stuck having to plea and say that she's guilty, well, that kid at a young age, and as someone who's adopted myself and who's struggles with a sense of abandonment, then they are asking the question themselves, why and what, to themselves, even if they aren't able to consciously be able to say so. That loved one is not there. That trauma does exist. And then we perpetuate that trauma. And then at the same time, we underfund or cut the service to process that trauma. And we create these cycles. And then we create this strong sense of individualistic blame on a person who might have committed a behavior that is in itself bad. But we have to ask the question, why? What are we going to do both in the front end of someone's life and during that period in which there was pain and trauma? And what are we going to do if someone is caught in the criminal legal system to make sure that they're uplifted as much as possible in the community around them? We live too often in a society that is individualistic and has an individualistic sense of freedom, but not a societal sense of freedom, not a community sense of freedom. And we're getting real big, and I know we want to talk about the PFA, but I fundamentally think that this is a conversation around freedom, who gets to be free, who gets to have liberty, who's allowed to be able to live their life, who's allowed to be invested in, and to get rid of the tiers that currently exist in the status quo, right? Fundamentally, money bond is about who has the privilege to be free, systemically based off of race and institutionally based off of wealth, and who is allowed to be free and who isn't. And even if person A and person B have a similar situation, but they have a different paycheck, that's a problem. That is fundamentally a problem. And we need to move away from that tier hierarchy. And we need to move away from what seems like, in a nerdy sense, a remnant of something very feudal. Now, we can get into that's a deeper conversation for another time, but it just fundamentally, I think that what we are doing in Illinois, what we are working on, is grounded in shifting the lives of people and improving the lives of people. And the people who've been invested in the status quo when it comes to public safety don't know what we need. And instead of operating from a place of fear, we're operating from a place of hope. And that hope is driven by a strong sense of community. And that community is what drives us to freedom and what drives us to liberty and drives us to the safety that we need in our lives. I am done with me ranting so much. I'm like,
amen, man. I'm with you. I think those bigger questions being this, I think I'm totally with you. I think this bill is about some really big stuff. I want to move to a question that came in from the audience, and this is from Jan Goldberg from the League of Women Voters and beloved member of Appleseed and the Collaboration for Justice's Criminal Justice Advisory Committee. And Jan asks, what do you think are the biggest misconceptions about the Pretrial Fairness Act? And I'll add, and what's the answer to them? What's the answer to those misconceptions?
So I think the first biggest misconception is it's not victim-centric. We had domestic violence advocates help so much with this effort, lead so much in this effort, educate us so much in this effort. And there's been an unfortunate series of conversations that are out there saying that this is not victim-centric and we don't care about victims. And that's just not the case. It couldn't be any further from the case. I would argue that once the PFA is actually implemented, you will see more levels of safety and security for victims. And I think this is how you get to a place where victims support this move. You have a Victims of Domestic Violence work group coming up through the Illinois Criminal Justice Information Authority to make sure this is implemented properly. So think about that, right? There's been a constant narrative that has said, we have ignored victims. We weren't at the table. You're ignoring victims. Entire work group led by victim advocates who have supported this effort is coming up through this legislation. There's a fundamental flaw in that argument, right? There are opinions and there's facts. The facts are simple. Victims advocates support this legislation. Victim advocates are working tirelessly alongside us to properly implement this legislation. We have to stop speaking for people and ask them to be at the table. This is why we have them at the table in the PFA. This is why you don't see us up grandstanding saying these people were left out from the table and left out from the conversations. Instead, we turn to them and say, lead the conversation, lead the implementation. Let's work together. So that has been one of the biggest misconceptions. And I think misconceptions is putting it nicely. And since the question, Jan, was misconceptions, we'll leave it at misconceptions, but we can talk about what it really is offline later on.
I'm going to say it's politics, but and it's always politics. Victims have always been used in politics by people who live in some of the safest places in the country. It drives me nuts because I live on the South Side. There was a couple kids shot. I have a friend who just got carjacked. Just the whole idea that the paternalism of talking about about safety in the conversation there is disgusting. And Garion is right on. I think the statement from the Illinois Coalition Against Domestic Violence is that the Pretrial Fairness Act is legislation that puts survivor safety first. Instead of using the same old talking points that we've seen from tough on crime people over and over again, who could give a damn about our safety, because I'm telling, this pisses me off more than anything in the world, because the amount of paternalism and bullshit that comes out of people's mouths thinking that they know how to keep us safe is fucked up. So I will say this very clearly. This is a bill that puts survivor safety first. Garion is spot on. And anybody who says otherwise is playing politics and playing a game. And if they want to play that game, they are defending a system for 40 years that have failed us over and over again. This summer is an indictment on them, not us. We are leading the fight to make sure that every community is safe. We want every community safe, and we're not going to play this bullshit game coming from the opponents and the people who've supported the status quo for so long. I shouldn't curse so much, but I'm not your traditional state senator, and I'm pissed, and I'm sick and tired. So I'll go back to Gary, and I know you were trying to make a point, but
no. You helped make that point. You can say things that I can't, Senator. So I appreciate you making that point. And we will also invite people to sit down at the table with us again about these issues, right? Because there was also a narrative that, there wasn't an open line of communication. We would more than welcome people to the table to figure out how we continue to create what Senator Peters has talked about throughout this conversation. Public safety for all, not public safety based on the zip code you live in, not based on the area code for your phone, but truly, what does public safety for all look like? We often talk about what is public safety. It should be the same in Ravenswood as it is in Inglewood, so on and so forth. So we would more than welcome having a conversation and working in collaboration with people who truly want to uphold what public safety is. But when we have those conversations, I would invite them to define what public safety is to them. All right. Once we hear what public safety is to them and we stop using public safety as a crutch, we often talk about public safety. Oh, this will decrease public safety. Oh, this will decrease public safety. How? Tell us how it will so we can work through that, because we're giving you solutions to experts, right? Not saying that law enforcement is an expert on what they're doing, but when we're talking about victim advocates, we're talking to those experts and we're asking them questions on how do we increase this safety. So let's work together. Let's bridge this gap. Let's work together. So, because this is coming. This is coming and we need to be on the same page. So let's get there.
Yeah, and just to get really specific, because I did a lot of the work that we sat down with DV advocates. When I say we sat down with DV and sexual assault advocates, I mean like we sat down with bill language and we gave them a red pen and said, okay, what works here? What doesn't work here? Where can we work together? And here's like just some of the things that are in the bill. Victim notification at every stage of the process. We don't have that now. We don't have a requirement that victims actually be notified if, for example, the person that they have accused of harming them is coming in and out of custody. And a lot of times they're not notified. And that can be really, really scary. It can really impact sometimes sort of always a sense of emotional safety and sometimes physical safety when you have that kind of situation. It allows people to get orders of protection at bond court, so that all that can happen in the same, or at the first court date. So all that can happen in the same, basic court proceeding, instead of having, survivors have to come back to a separate proceeding and come back to the courthouse again to try and get an order of protection. I mean, it treats misdemeanor domestic violence, which is a misdemeanor, but is the most common domestic violence charge. It puts it in the same category with other violent charges, with other violent felonies, instead of putting it in the same category as trespass or other like low-level misdemeanors. We make a much more rational distinction about what's a serious crime where there might actually be a threat to safety and what's not. And so these are concrete things. And I think that, my question often to people who oppose the bill is, so you oppose those things too? You think survivors, seriously, like that we really have a bill that makes things better for survivors. And I think that, when people criticize the PFA, they should know what the heck they're talking about. Another question from the audience is, and this I'm going to direct to Senator Peters because it's a political one, is simply whether we're concerned that there's going to be any walk back of these reforms in the next legislative sessions, and what do we do about that?
I think you have to always be concerned that there's going to be walkbacks. I mean, the proponents of tough on crime, let's be honest, they're going to double down on their belief. I mean, I think oftentimes the narrative about this summer is in response to, a broad coalition of people who were out in the streets in 2020 demanding change. So I think that, yes, there's always going to be the risk of walkback. But what I will also say is that for all of us, we're doing the work to try to mitigate and prevent that risk, right? Whether it's organizing on the ground, whether it's organizing in the Capitol under the dome, it's organizing the narrative, we're doing whatever we can, but we should always be, prepared for the risk of someone trying to walk back what we've done. And we should be vigilant in fighting back against that. I don't want to live in a la-la land after what I've seen in California and in New York, and we've seen how in Cook County it's attacked. I mean, it's amazing how many people will blame bail all the time for what's happening in Cook County, and not the fact that we've had a mass eviction since the Great Recession. Obviously, somehow the foreclosure crisis has nothing to do with what's going on. Obviously, the closing of schools has nothing to do with what's going on. Obviously, closing mental health facilities has nothing what's going on. Obviously, raising the bridges and dividing the city up has nothing to do with what's going on. It's got to be everyone's favorite punching bag, which is the fact that we've done bail reform. And so we've done a good job fighting back that in Cook County, right? It's still there. It helped to lay the foundation for what we're doing in Illinois. And we've got to keep being vigilant to make sure that we don't see this happen in Illinois in the legislature. I know that I'm going to fight every day to make sure there's no walkback. And I know that I'm fighting with organizers and a coalition that's doing that. What I also know is that they're going, because it's almost always political, and because, let's be honest, it's sort of a dog whistle at this point to attack bail reform and EM. It's a very subtle dog whistle. I don't give a damn if you're white, black, or Latinx. You're participating in a dog whistle. You're participating in a dog whistle. And it's always a dog whistle because people are afraid to actually say what we need to do to make our community safe, because that is a dynamic that is very material. So when they can't answer for the fact that they're standing up for a status quo that's failing, they're going to attack bail. And at some point, you've got to ask, and what then? And what then? And what then? Until you've decided to say that you want to mass arrest people, particularly Black people. And we're not going to do that. People who want to actually give people the freedom and liberty they deserve are not going to walk like, lemmings down a line towards a mass incarceral system that recreates the worst elements of neoliberalism and feudalism. That is something that we cannot do. It's not that era has existed and it has continued to fail us over and over again. And in fact, whether you live in Streeterville or South Shore and you experience the same anxiety, that is one heck of an indictment against that system. And it goes to show that fundamentally our economic and political systems are collapsing on itself, not being able to provide for people. What we are saying is make sure that people, it's important to remember what bail is, it's cash. Make sure that people have money in their pocket so they can put food on the table, or their kid can have a backpack, or their kid can get a bus pass, or you can get a bus pass to get to work, or you can pay for rent to have a roof over your head. That is going to provide people safety. As Garion said, when we look at this, there should be no difference between Ravenswood and Englewood. There should be no difference between the North Shore and the South Shore. There should be no difference between Chicago and downstate when it comes to the services that you need. That is our job. It seems like a task that we've been told is impossible, but it's amazing that we're told it's impossible all the time. And yet here we are on Zoom over magic airwaves to be able to have this conversation. What is and isn't possible is something that some other people seem to have decided for us. I believe it's very much possible. I believe it is there. And we just take that small step to make sure some people keep some money in their pocket to be able to pay for the food that they need that day, or to pay for that bus pass, or to make sure their kids have good shoes so they can walk down to school and walk in class. That is fundamentally that's a small thing that I think can be a big change. So I think, yes, there are going to be people who are so tied to the status quo that they're going to double down and try to fight this. But I also think that we, whether it's us organizing the legislature, us organizing the Capitol, or us organizing the streets, are going to continue to do the work to protect what is a historic, transformative change to give people public safety for all.
Yep. Amen. I don't have anything to add to that. I'm good. This is a question that's a little more technical, but I think is something that comes up a lot, especially in lawyers' brains. And the question is about the financial impact of these reforms. And the specific question that was asked is whether we're worried that the state is going to try and increase fines in other areas of government or other areas of the court system to try and cover the losses from bond. But I think the more important question is sort of, what do we do about the financial impact, if any, that this bill might have on governments, on courts, on counties throughout the state?
Well, first and foremost, we should have moved away from systems that are built on the backs of people in the criminal legal system long ago and far away. There's a colleague who I think is brilliant, who's down in Decatur. She's over in Macon, right? She ran a teen court that was housed in the state's attorney's office, and she saw it was built solely on fines and fees. So she took that model, took it over to Millikan University and said, we won't be using this based on fines and fees anymore. So she took an entire model out of the state's attorney system, put it in the university system. Now, again, this goes back to the magic airwaves that the senator talked about earlier. Too often we hear about things you can't do. Well, there's a prime example of things you can do. We should be challenging ourselves to move away from a system that is predicated solely on the backs of people who are not solely, primarily, almost solely,
Mostly.
predominantly Black and brown folks. We have to move away from that. We have to think deeper about how these systems impact folks. We have to think deeper about what these losses mean. And we need to hold a mirror up to some of these systems and ask, how have you been this structured? How have you built your entire system off of fines and fees? And I know we've done a lot of work to reform the fines and fees systems here in Illinois, but we really need to have a true conversation around why they felt like it was necessary to build an entire system on that structure. Who is responsible for where those dollars go? How much dollars? I mean, I would love to follow a bond dollar through the entire system, right? Because you have so many jurisdictions worried about losing that revenue. But so many of those same jurisdictions can tell you how much the revenue is, what they've been using the revenue for, how it's benefited the folks there. Let's take a step back and get folks to answer some of the questions, because we've been answering questions for the last 5 years, and we're going to be expected to answer questions for the next 2 years. When do we get to turn around and say, okay, we've changed the system because it didn't work, but tell us what you were doing in that meantime. Where are those dollars? Where are they? That question is a question I think we should be asking folks as well.
I would add to this that the bigger question I have about how much money this is, when people say, well, this is going to cost us a lot of money, is, well, it's also going to save you a lot of money. You know, one of the things that it seems doesn't get mentioned in these conversations about funding is that the absolute most expensive thing to do when someone is accused of a crime and is pretrial is to jail them. Undeniable. I don't care what pretrial system you put into place, it is going to be cheaper than jail. Jail is incredibly expensive. And so when one of the key things about the Pretrial Fairness Act is that it is going to decrease pretrial incarceration. And for counties, that means savings. We've already seen here in Cook County that, we've been able to decrease our jail population by about half since 2014. Now, here's the catch, and this is what's happened in Cook County, and we got to make sure it doesn't happen elsewhere. You have to take those savings and move them, right? So now mostly I think you got to take those savings and move them into communities to support people who have been impacted by the system, to give people the services they need. Certainly in Cook County, the savings are so huge that there is plenty to go around. But if there are, costs that need to go to the court systems, that is certainly one place to look for that money. The key is, and we know this, right? A lot of times the money's in two different pots. You got a sheriff's pot, you got a court pot, you got a county pot, you got a property tax pot, you got all the different pots. And we have to actually make sure that we don't have sort of protection of everybody's individual little fiefdom, to use Senator Peters's feudalism example, stopping that money from flowing around. We have to dismantle the system for real. In Cook County, I'll give a shout out. That means the budget for Black Lives, which is something that the Collaboration for Justice supports and has been pushed by the People's Lobby and a bunch of other groups that talks about where some of that money from the sheriff's budget and police budget should go. But we need to be doing that throughout the state. And we need to make sure that when counties do come to us and come to the public with this idea that they're going to lose money, that we ask the question, well, what about the money you're going to save?
Yeah, and Sarah, we can't shout out the budget for Black Lives without showing some love to Tanya Watkins and the work that folks doing.
Yes.
Tanya's
I was forgetting someone too. When I said People's Lobby, I was like, no, and Tanya and Sol are a huge part of that, and did amazing work recently in a direct action that was really inspiring. Another question that came from the audience that I really liked is, what can citizens do? What can individual people do to help change the narrative about bond reform, given the pressure that's coming from a lot of very loud voices in the conversation?
I mean, I fundamentally think, like, join look, I'm trying to be chill now. This is a new effort. But I think fundamentally being part of an organization, getting involved in an effort where you're working in a relatively collective effort to battle these narratives is important. So I just say get involved. And there are a lot of organizations. I mean, we've heard, from grassroots organizations like the People's Lobby and Soul, to the work that folks are doing at ACLU, what you guys are doing at Appleseed. What everybody's just doing is that there's a whole coalition with different organizations taking different spaces and step into that. So that's that. And if you say, like, I don't have that much time, just a little bit of time, even if it means, learning more about the issues, right? And then taking that information that you're learning. And when you hear from a neighbor that says this such and such thing happened due to this, and sort of correcting that sort of mis or disinformation that exists out there. One of the things that I think one of the critiques or misconceptions that happen is that people think that we actually ended cash bond already. So I was at a Illinois Municipal League, which represents all the municipalities in the state. And someone said, I said, well, people are showing their, using my foul language, showing their ass when they say that we've instituted ending cash bond, like that's already law. And someone literally 10 minutes later, who clearly wasn't listening to my answer, gave this whole scenario and said that they couldn't arrest this person because we ended cash bond. And me and Senator Sims and Rep. Slaughter all just, our eyes got wide. We were like, there it is. And it's amazing how many people think that we've done something that we didn't happen, which says everything about the seriousness of the people who are opposing this. They're not even focused on the reality. It's a bunch of disinformation about what we've done. To repeat, what we're talking about is something that will truly go into effect or fully go into effect on 1/1/23. And I think just informing people when they talk about what we've done do they even know that it doesn't actually go into effect for another 14 or so months?
What I would add on to is everybody here, everybody in the state has a representative, as a senator. They represent you. They work for you. Spend time with them. Because when you don't spend time with them, you are ceding power and ceding that narrative to people who may be opposed to your views, opposed to your interests. Spend time with those representatives and senators. Express your concerns, express your support for issues. Get a better understanding of why they vote the way that they do. Make your voice louder, make your voice heard. Elected officials shouldn't turn down meetings with constituents. They don't, a lot of them don't turn down meetings anyway. But if you live in their district, your voice should be heard because they are representing your interests. So that's how you get more involved, understanding who your senator and who your reps are. Go and talk to them on a regular basis. Make yourself a mainstay in their district office, right? If you're over in Hyde Park, make yourself a mainstay in Senator Peters' office. He'll open the door for you. He'll have conversations with you. He'll brainstorm with you on how to get things done. Then he'll go out there and do it. So I think that's a major way you get involved. I think that's a major way you raise your voice, right? Especially throughout other parts of the state. If you're watching this and you're down in Harrisburg, think about how you can go and reach out to folks. If you're watching this and you're in Decatur, Rockford, wherever the case may be, understand that you can reach out to those elected officials, express your concerns, offer support, and kind of build from there. So I think this is how you work on the narrative change. You work on letting people know who represent you, what your interests are.
Yeah, and I'll just speak a little bit to, I guess, like people who look like me for a sec. One of the big battlegrounds in our fight we found was that this narrative against bond reform is winning in the suburbs. It's winning, like Senator Peters said, in some of the safest communities in the state, right? And I think a lot of times, because we live in a democratic state, because we live in a relatively progressive state, there are lots of people who think that their networks are just an echo chamber, right? That like talking about issues about progressive issues doesn't matter because everybody already agrees with them. And the truth is they don't, especially if you are in the suburbs. But if you are anywhere, if you live, hell, I live in Lakeview, like my neighbors do not all agree with me about this, okay? And they have not heard about bond reform and what it does. And they are hearing these really loud negative voices. So talk to the people around you, use social media, spread good information, because that's how you really magnify your impact. And you may, particularly if you are somebody who, is politically involved and knows that you're in one of these communities that's really susceptible to that narrative that, the world is becoming less safe and, we're all in danger. And there's a very specific, let's call it what it is. It's not just a dog whistle. I mean, it's a racist narrative that is often targeted towards white communities to say, hey, bond reform is going to make you less safe. Fight back against that if you are in those communities. That's absolutely the least that we can do as allies to this fight. So I'll say that. So another question that came in while we were, it was to talk about whether people are going to show up to court. It came in as a question that was about, well, do we have to worry that people aren't going to show up to court? But I think I want to ask the broader question. What's wrong with how we think about court appearance? And how does the PFA fix it? I know it's a really broad question, but I think it's something we don't talk about enough.
I mean, I think that people often miss court because of work or lack of childcare. I mean, there's a whole host of other things, but it's interesting because it's the same sort of conversation we're having right now about the workforce, that people lacking childcare they're struggling to go to work. And so we're seeing like a thing together here. I think the PFA is it doesn't necessarily provide you childcare, but I think understands that you need space and time to be able to figure those things out and not be punished. So I think we have, if I'm correct, a 48-hour window before you can issue a warrant, because it essentially saying, hey, you might have, oftentimes when people miss court is because of these two situations involving childcare and work. So instead of immediately saying you're going to get punished with and given the hammer, to get checked in and then to see if what's going on, and then to give you that, hey, you need to come in at such and such time. I think that's very important. What the conversation that's been happening recently has been completely against that, and I don't know how that's going to make anybody's lives better. I think that, again, if you have a little kid that you're just kind of stuck with, I mean, that you have to take care of. I don't mean that in a negative sense, but you have to take care of that kid. Not even be able to provide that space shows that the contradictions of our status quo. And I think that PFA is trying its best. I mean, I think we can't solve every contradiction, but trying its best to address the contradictions of services and our criminal legal system and the punitive nature of our criminal legal system, to provide some space to make sure that people, so that they have a little bit of space in that realm. That's my feeling, and I think it's important to ground that these things aren't in silos, that they're very intertwined.
Yeah, I think it's also really important to lift up some of the work that has been done as a result of the PFA. So the Administrative Office of Illinois Courts, under the guise of the Supreme Court, has looked into creating a pretrial services group, right? And what that means is, how do they provide pretrial services to make sure people are able to make it to court, get the support they need, get the help they need? This is very early in the process, but that's an example of an entity saying, all right, we need to fix this. Right? You have certain jurisdictions across the state who have had 30 years to provide pretrial services and provided nothing. So now it's an opportunity to pull folks together at the table to move away from the question of what happens, how do we get, what are we supposed to do? What is our responsibility to the people? what is our responsibility to the people that we serve? So now, again, this is another opportunity to flip that question on its head and work in conjunction with allies and some unlikely allies to figure out how we come to the table together to help folks who may need support, who may need assistance, who may need reminders, whatever is necessary. And we need to do that in conjunction. We need to do that in conjunction with people who are responsible for implementation. We need to do that for people who, in particular, have been impacted by the system, who can tell you deeply around what were some of the things that they needed to make sure that these things work for them. So as we go through that process of looking at a pretrial services system to work alongside the PFA, these are some of the things that we have to keep in mind. So the PFA opened a lot of doors. It opened a lot of doors, and this is one of the ones that we're really excited about.
Yeah, I'll just tell another, war story, because every part of the PFA for me has a person attached to it, somebody that I worked with. And this guy's name is generic enough that I'll say, like, I think of the failure to appear stuff as the John section, because I had a client named John. I had a lot of clients named John. But okay, so it just really, his situation showed how ineffective the current system is. So his wife works full time. He can't get a job because he's got a felony conviction. So he's full-time dad to their 3 little kids. They had a 3-year-old, a 2-year-old, and a 6-month-old. I did not know how, that it was terrifying to me. So many babies. All right. So John's got court. He can't find childcare for his kids because they can't afford childcare, which is why John's a full-time dad, right? Now, he can't bring the kids to the courtroom because the judge will hold him in contempt if he does, because his baby's going to cry. Now, he could leave them downstairs at the childcare center downstairs, but here's the problem. John's already missed court, so he's got a warrant for his arrest. So when he comes into court, he's got no idea if he's going to get taken into custody. And if he does, then his kids, and then they end up calling DCFS on the kids, because the downstairs childcare, at 26th Street, doesn't know who else can pick them up or what else is going on. And you open up a DCFS case, which is the last thing that John needs. So instead, John calls me and he's like, Sarah, I'm not going to court. What are you talking about? I know I have to resolve my warrant, but I'm not going to go to court if this is the only way, because I don't have any way to make sure that my kids are safe, right? And that's the kind of thing that is just, and so I think I hear a lot that, well, people aren't going to show up to court and it's going to make the courts less efficient. Well, what I just described makes the court a heck of a lot efficient. We waited 8 months for John to come into court, and I don't blame him. I wouldn't have done it if I were him, but we waited 8 months for sort of figure out everything, make sure that he felt comfortable knowing that he might go into custody if he came in. He did end up going into custody when he came in. He did have his kids with him. We did have to figure out what was going on. And so we need a system that treats people like human beings. Most people don't miss court because they're trying to ruin somebody's day at the courthouse, right?
Yeah, this isn't America's Most Wanted. People on court to abscond away.
By the way, John was charged with
to go get out of here.
Yeah, John was on probation for possession of a controlled substance, by the way, just to be clear. So we are talking for I think less than a gram of heroin. So we are talking about a just crazy amount of court inefficiency. And of course, John had a warrant out this whole time. So he's living in constant fear that if he gets stopped by the police, he's going to get arrested and his kids are not going to have anyone take care of him. So it's a cruel system. It's an inefficient system. And ultimately, the system we replace it with is better. It makes more sense. And because it's more humane, it will also be more efficient because it actually treats people like the human beings that they are. I'll also say all of the states that have gotten rid of cash bail have not seen a rise in failures to appear. It just didn't happen. So I think I'm gonna wrap up there. I really want to thank y'all for being willing to participate in this panel. Any last words for folks before we let them go?
It's okay to curse in certain settings. Please be careful with your mouth. No, I just want to say thank you so much, Sarah, for doing this. Thank you, Chicago Appleseed, and thanks to everybody who's doing this work. I think we should be proud, especially if you live in Illinois, of what we've done. And though there's still so much work left to do, oftentimes being from Illinois or being from Chicago, we have sort of a self-deprecating nature about who we are and what we are. And we shouldn't let people put us down like that. We should actually be going to other states and telling them to be more like us. I have a friend who's in Massachusetts, and we're working to end solitary confinement. That's a big one. And he sort of bragged to me about it. And I said, oh yeah, well, end cash bail. And of course, I think that's just something where you can say that to another state. And instead of what has been historically Illinois, the joke, ha ha ha, or Chicago as used as a punching bag, even by people who live in Chicago. We shouldn't have that. We should be very proud. We should be proud as a people. And so the reason why we can have that pride and we can go to other places and do that is because of the work we are doing in a collective manner in a variety of spaces. And so I'm grateful.
I would just like to thank the team at Chicago Appleseed, Sarah, and thank the Coalition and Money Bond members. Those folks work tirelessly. And, it is very important that we also thank Senator Peters, Senator Sims, and Representative Slaughter for their leadership. Because I can promise you, right, he's smiling now, but they had to fight a lot, and they still have to fight a lot. They are fighting in rooms that we don't know anything about, and it's our responsibility to keep not only pushing them, but when we push them, we're pushing them with support because they know the ultimate goal. We know the ultimate goal, and it's important that we all continue to work together. And please, 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 if you don't take anything else from this, learn who the reps are so you can also help inform and educate them about the things that are important to you as we continue to move this work forward. Thank you all for the opportunity.
Before we go, I want to thank today's participants, and I also want to thank Ellen Rosen and Natalia Vera for their wonderful introductions here. I also want to thank our donors, our President's Circle members, and our event sponsors who sustain the work of the Collaboration for Justice. The Collaboration for Justice really relies on events like this and the people watching them to get our work done. More than 40% of our annual budget comes from the generosity of individual community donors, volunteers, and council members. And we could not do the work we do without their steadfast support. We're going to need that steadfast support going forward as we try to implement this huge, monumental, historic piece of legislation. We would like to join that fight and support our fight for fair and accessible and effective courts and beyond. Please use the donation button that is in your little interface or go to chicagoappleseed.org/donate. And thank you so much for attending this presentation and for all of your support. Thanks a lot, everybody.